Okay, so today we want to look at the question of sources, and this is especially important in international law. So why sources matter? When you are a judge and a dispute comes to you, you have to issue a verdict, and that verdict needs to be issued based on pre-existing law. Therefore, it's very important for you to understand where to look at, and that's where the idea of sources come into existence. So sources are where you go in order to resolve a dispute. And we need to see what those sources really are as regards human rights. Before we do that, we need to provide a note about the nature of human rights. Human rights as a legal system are subsumed under the broader category of international law. So what we did last week was to look at human rights through domestic systems in England, in France, in the Roman and Persian empires. But what international law does really is to expand the reach of laws into the relationship that states hold with one another. So international law is a branch of law that regulates the relationship amongst states. It is a state's focus. In other words, the basic unit of subjecthood or personality in international law is states. International law is first and foremost concerned with the conduct of states. It's a state-centered system. And 95% of legal instruments in international law really concern states. But after the Second World War, an important realization was made by the international community. And that realization was that individuals are not sufficiently protected. And there has to be a new mechanism of protecting individuals. Before that, individuals were left at the mercy of states. In other words, states could do whatever they desired to individuals, and nobody could go to a sovereign and say, why you showed that type of behavior towards your own citizens. Citizens were not protected. So basically here, the lesson was that individuals need to be protected against their own states. And that's what human rights does. Human rights protect individuals against states. And this was revolutionary after the Second World War. The reason was that for the first time in our entire history, individuals found an expression in the international arena. Of course, the price we paid for that was very, very heavy. This realization was made in the wake of the Holocaust, and only when the ugly truth about the Holocaust came to light after Nuremberg trials. So the Nuremberg trials were the moment where these under protection of individuals was understood by the international community, and this was when the Universal Declaration of Human Rights was adopted. So we'll come back to the Universal Declaration of Human Rights, but the fact that human rights as a discipline belongs to international law means that in order to find the sources of human rights law, we need to look for the sources that are acknowledged as authoritative, as bearing authority in international law. And the place that we find that is in Article 38 of the statute for International Court of Justice. This is where you expect to find the sources because, well, International Court of Justice is the UN judicial body. This is where most disputes, when they cannot resolve, states cannot resolve their disputes through other peaceful means, they go to International Court of Justice in order to have their disputes litigated before the World Court. So that's where you expect to find the sources, because it tells the judges, if you basically encounter a case, a dispute, these are the sources to which you need to refer. And these is a preliminary list of those sources, and we want to go through them one by one. The first and most important source of international law is treaties. Treaties are conventions, legal agreements that are enforceable by international law and are concluded between two or more states. If you have two states concluding a treaty, it's usually called a bilateral treaty. If you have more than two states, you have multilateral treaties. Treaties are very old, even though it's in the modern age that we have proliferation of treaties exponentially, but they are very old. The first treaty goes back to the year 1254 BC. 1254 BC, and that's called the Treaty of Kadesh. This is between Ramses II in Egypt and a civilization that lived in today Turkey's Titis. And what's very interesting about that treaty is that the original clay containing the treaty survives in two languages, Hieroglyphian and Akkadian, and it's very detailed. And it basically governs the relationship between these two emperors. And there are some very interesting clauses about fugitives. So basically, these two emperors agree that if there is a fugitive fleeing from one into another territory, they will be extradited. So this became the basis for a later practice that we call extradition agreements. If somebody commits a crime in one country and then escapes to another country, and if there is an extradition agreement between the two states, the state in which the fugitive has taken shelter is under an obligation to capture and extradite the individual into the treaty, into the territory that has jurisdiction. So treaties are very, very old. But they've been mostly the case in relationship between states in the 20th century, and there are hundreds, maybe thousands of treaties, right? We have a convention in international law, we have a treaty in international law that governs treaties. This is called a treaty about treaties. This is called Vienna Convention on Law of Treaties, 1969, right? So very early on, states understood for them to enforce treaties, they need to agree on some rules about treaties' validity, how they are interpreted, how they are enforced, and that's called the Vienna Convention on the Law of Treaties. Of course, we have so many names for the same phenomenon. So, for example, the document that constituted the United Nations is called the UN Charter. And the UN Charter is a treaty that's agreed upon by 193 states. So the UN founding document is a convention, is a treaty. We don't call it a convention there, we have just chosen another name, we call it the UN Charter. And the UN Charter is a treaty. So many international organizations, as their founding document, have some sort of charter that is usually a treaty. So some other names that we call treaties by: pacts. Pacts usually refer to treaties with a security underpinning. Conventions, covenants, agreements, sometimes memorandum of understanding. Though memorandum of understanding, some people say they're really not treaty, but these are some different names by which we call the same phenomenon that are treaties. So I'll come back to treaties, but for now, I just need to I need to mention that the way treaties are adopted, the established practice is that states negotiate a treaty and then they initially sign the treaty. So those states that sign a treaty are called signatories to that treaty. So the first stage is to sign a treaty, and the states which do that are called signatory states. But that's not end of the story. Signatory states take the content of the treaty and to their sovereign bodies. Usually parliaments are entrusted with that task, and then states' parliaments need to ratify the treaty. So when you sign a treaty, that does not make the treaty binding for you. It just indicates your intention to be bound by that treaty. You take the document to your sovereign body, mostly parliaments, and parliaments adopt the treaty, they ratify the treaty. So when a state ratifies a treaty and communicates that their ratification to other states, that treaty becomes binding for them. When you sign a treaty, that treaty is not binding for you except for some general principles. So the general principle is that when a state signs a treaty, they cannot take any action that flies against the object and purpose of that treaty. So when you have signed a treaty, your only obligation is not to do something that contradicts that treaty. And you may say, well, I mean, that's obvious. No states do that really. What type of states sign a treaty and then they decide to violate that treaty? But it's, it's often the case in international law that a state may remain signatory to a treaty for many, many years. And then sometime down the road, they decide to take actions that are totally in contravention of their treaty obligations. So for example, the United States signed the Rome Statute. That's the treaty that established the International Criminal Court. And it did that in the last days of Clinton administration. When the Bush administration came, the United States entered into bilateral agreements with other signatories to the ICC statute and other state parties to the ICC statute, and basically forced those treaties forced those states not to extradite a US national who had committed crimes under the ICC statute to the International Criminal Court. Well, the US was a signatory and still was doing something that would violate the object and purpose of the treaty that they had signed. And later on, the US said, you know what, I make it easy for you. I withdraw my signature. So basically, they withdrew their signature and continued without the ICC statute. So it happens a lot that a state may be a signatory and not ratify a convention for many years, or will never ratify a convention. Sometimes states just do that in order to show good faith, to show that they agree with the logic of that treaty, but it's not in their interest to ratify that treaty altogether. Treaties don't become enforceable until they've been ratified. And usually what they do, if there are multilateral universal treaties, they kind of specify a number for states that need to ratify that treaty. So they say that if the state parties to the treaty reach the number of 32 states, or when the state parties reach the number of 32, the treaty becomes binding. So it's when you see that a treaty has been adopted and it comes into force so many years later, it's because it has reached the number of ratifications necessary for it to become binding in many years. There are some treaties that have been signed and have never reached the number of ratifications necessary. So they've never been binding. So for example, we have a treaty called the Treaty on the Responsibility of International Organizations. Okay, this was adopted in 1987. It hasn't yet become binding. So it's been 38 years and the treaty has not reached the number of states necessary for it to become binding. You may say, well, I mean, this practice of ratification, where it comes from, why is it an established practice? This goes back in many years as well. So usually what happened in wars was that wars were fought by some princes or by some warlords, and then in the midst of the war, the two parties would come to an agreement and they would agree on the content of an agreement. But this was not end of it. They had to say that we'll take this letter, this agreement, to the king, and when the king ratifies or approves our agreement, this becomes binding on us. And this tradition has remained intact for so many years. This also, has ancient roots. Some of very famous treaties in the ancient world are treaties between or amongst Greek city-states. Also some very popular treaties in classical studies. Nibici Treaty between Persia and Rome, the Eternal Peace Treaty between Persia and Rome. This was 298 CE, and this was what gave rise to this practice. In international law, when you have an established practice, it's very hard to take a departure from that practice. Doesn't matter how irrational sometimes that practice could be, but this was practice back then. It has remained the law thus far. So that's how treaties are ratified. Of course, in bilateral treaties, you don't have that problem because it's very rare for states to sign bilateral treaties and not ratify them later. But sometimes, for diplomatic games, states may do that even with bilateral treaties. So states have a disagreement and they want to make some promises that look good on paper, but they never have the intention to enforce what they have agreed. The easy way out for them is to sign the treaty and never ratify it, right? That's kind of a known game in international law. So that's treaty. And as I said, when talking about treaties, we go to Vienna Convention on the Law of Treaties. Yes?
When ratified, does the treaty become part of that country's domestic law as well? Or is it only just like beholden to the international law?
Great question. States differ about how they interpret treaties as regards domestic laws. So there are basically states that have a dualist system. They say we have international law obligations and we have domestic law obligations. And these two are separate and they approach them separately, okay? And there are states that actually say international law is becomes a part of our domestic law, and it's just like, it's treated like a domestic piece of legislation. So for example, in the US, when the US government, also in Canada, they adopt a treaty, when they ratify a treaty, this becomes part of the domestic laws. But that there is a downside to it, because in the US domestic law, it's acceptable for the parliament to adopt legislation that would basically create new law and would do away with a previous legislation. So if international law obligations are part of the domestic law, then the conclusion that they have drawn is that it can be changed by domestic law. So in the US, international law becomes part of domestic law, but domestically they may change it. They may enact legislation that would abrogate. Well, there are violations. Violations don't mean that the legal system is necessarily weak. It means that its rules are enforced through a very different procedure. So there is treaties, but older than treaties are customs, right? So customs or international customary law is the second primary source of international law. And really the word custom maybe derives from the common law tradition where the main source of law is custom. Though in common law tradition, custom means judicial precedents. So when you hear the word custom in common law systems, don't assume that custom is referring to some peculiar cultural practices or practices followed by individuals. A custom in the common law system means judicial decisions that have been made by courts in the past. But in international law, the word custom has a different meaning. The term custom in international law refers to the established practice by states. So in order to identify a custom, you need to look at whether this is established practice. And there are two elements to this, two elements of custom. The first element is what we call the material element, sometimes called the objective element of custom, and that's a state's practice. That's what states do. Okay, so for example, this established practice of signing and ratifying treaties is a custom. That's a very established custom, and that's what states do, and that's the material element. There is also a subjective element of customs, and subjective element in Latin is called opinio juris. So this is the subjective element or opinio juris. In international law, we're obsessed with Latin terms. We use a lot of Latin phrases, and this Latin term means a belief held in obligation. Okay, so opinio juris is states undertake certain actions believing that they're obliged to do it. So they have this belief in obligation. This is very important. And for a custom to become binding, it has to have both elements. Because states undertake many actions knowing that it is illegal. For example, torture is widespread. Unfortunately, the majority of states, at least at some point, have engaged in acts that could be considered as torture. Okay? But that doesn't make torture an established custom, because states engage in torture despite their knowledge of torture's illegality. Okay? So custom basically, opinio juris basically means that the states need to have an understanding about the nature of the act. Also, it means that when states engage in practices out of courtesy, that doesn't make it a custom for them to be bound by. It's, an act out of courtesy, right? And there are many different examples of this, right? How a state's official is received by another state, the type of meals that are served, these are all courteous acts. States don't act out of a sense of obligation. These are acts of courtesy. So these are the two elements of custom. And between treaty and custom, really, treaty means to codify law. Sometimes it codifies custom. So sometimes there are established practices that are widely considered as customary law, and a treaty wants to unify the practice and solidify a particular brand of practice, and it codifies that practice into law. For example, Vienna Convention on the Law of Treaty. It was, for the most part, codification of customary norms that already existed among states. Sometimes custom is codified by treaties, and treaties codify custom in order to create a uniform approach and in order to give clarity to the custom. Okay? So when you see treaty, it really doesn't mean that treaty is against customs. Treaty can codify customs. Also, international customary law and treaties are equally binding. There is no hierarchy saying that a treaty needs to be given priority. Customs are in fact older. You know, the international order used to be governed by practices that were customary and not codified for the most part. It was only in the 20th century, in the 19th and the 20th century, that this practice of documenting agreements become more popular. Also, customary law may have one advantage. It takes years, decades sometimes, for a treaty to be negotiated, for a treaty to be produced. And in so many areas, you already have customary law that governs the relations before treaty law. So customary law sometimes is a faster way of approaching things and a much more efficient way, but there is a disadvantage here. The disadvantage is that states that are stronger, states whose conduct carries more weight, are perhaps more instrumental in creating custom. Okay, so for example, we have a concept in the law of sea called, we have maritime zones, and we've got about 6-7 maritime zones. And one interesting maritime zone is called continental shelf. Continental shelf is the continuation of coastal lines into the seabed. And the very concept of continental shelf was invented overnight by the American executive through Truman's declaration on US freedom to use its continental shelf, right? So the entire thing became an overnight custom, okay? Or for example, we have a customary law on the freedom of space, which means that states have freedom to explore space, and that custom was created with the first type of satellite vehicle that we wound up sending out to the space. So sometimes customary law can become very ambiguous, but still an important source of international law. In international law of armed conflicts, very important, another important area of international law is called international humanitarian law, and it shouldn't be confused with international human rights law. These are two very different areas. In international humanitarian law, you have treaties and customs that govern the conduct of states during warfare. And much of those conducts you can identify through military manuals, types of instructions issued on different issues, and that's how they identify custom. International Committee of the Red Cross is tasked with identifying customary law in international humanitarian law, and it has these voluminous books that basically tell you what the customary norms are. Customary norms are especially important when you have a lack of clear rules or treaty, when treaties are absent. For example, when it comes to internal armed conflicts or civil wars, we have a deficiency of treaty norms. And what jurists do is to try to locate the customary law through military manuals, through the pertinent practices, and basically identify them, probably write articles on them or publish customary norms, books, like the ICRC has done. Okay, so that's how you identify custom, though it's very, very ambiguous. We have a very famous case in international law called the North Sea Continental Shelf case, or to be short, the Continental Shelf case. It's about the identification of customary norms. And it's adjudicated in International Court of Justice. And there is a dispute amongst three states: Germany, Norway, and Netherlands. And each one of these states want to claim a bigger shelf of the continental shelf of the North Sea. And the ICJ basically says that in order for a norm to be considered as customary, the overwhelming majority of states need to conform with that rule. So basically here the principle is that you have to establish whether practice is customary, but also you have to locate whether the overwhelming majority of states support the customary status of that norm. It becomes very, very difficult at times, and also not consistent. Because, as I said, in some instances you only have one state that can create a customary norm. So as I said, as regards the very concept of the continental shelf, it was created overnight, or the principle on freedom of space. There are many, many examples of genocide cases. The clearest, and sometimes those situations can be contentious. So for example, the situation in Gaza is very, very contentious as regards the definition of genocide. And I will, later on, will tell you what types of definitions we kind of apply to the concept of genocide. But for example, the situation in Rwanda is the clearest case of genocide in 1990s, where over 100 days, about 1 million Tutsis were slaughtered. And then there were states that would supply the Hutus, the perpetrator of that genocide, with arms. France and Belgium, to name two at least. Yes, but in general, the principle is right. If you can establish that the situation amounts to being a genocide, then yes, that treaty is not valid or shall not be valid. Or if a state realizes that the situation is genocide, then they can cancel the treaty or not carry out their obligations under that treaty. Okay, so that's jus cogens. And jus cogens is so important that when a jus cogens norm conflicts with another treaty, not some provisions of that treaty, the entire treaty that is in contradiction with the jus cogens norm is considered as void. Void means without any legal effect. So when a treaty conflicts with a jus cogens norm, then the entire treaty is void. The entire treaty is invalid. Not one or two provisions that conflict with the jus cogens norm. So prohibition of genocide is a jus cogens norm. Prohibition of slavery is a jus cogens norm. So states basically, if they interact with one another in a way that raises the suspicion of approving a slavery, those types of actions are not valid. The formal determination needs to be made if the case is litigated by International Court of Justice. It's very rare. It's very rare for actors to draw that type of conclusion, but still we need to be mindful of the practice and how it has evolved. So that's jus cogens, prohibition of genocide, prohibition of slavery, prohibition of crimes against humanity, prohibition of racism and apartheid, and another norm that, although more contentiously has claimed a jus cogens status, is the principle or the right of self-determination, though self-determination is a much more contentious example, because many states would tell you, well, you know, self-determination really doesn't have that much legal weight. And to some extent, that argument has some value. I will consider that in greater detail when we consider self-determination. That'll be on week 5 or 6, I think. So that's jus cogens, and jus cogens is on the top of the hierarchy. Jus cogens shouldn't be confused with another very flowery Latin term, which is erga omnes. So these two concepts are very similar, but they have different applications. Jus cogens refers to the nature of customary norms. Erga omnes looks at the element of interest. So erga omnes, jus cogens is used for resolving norm conflicts. But erga omnes basically rules on how states may perceive another practice. Okay, just to clarify this, let me give you an example. Prohibition on the use of force is a very important norm in international law. So basically what this means is that states cannot invade another country when they like. There is an outright prohibition on the use of force except for self-defense. So states cannot invade other states except for self-defense. And if a state finds itself invading another country, some other states may choose to intervene. And they say that we intervene militarily in order to fulfill our erga omnes obligation. So if I want to give a very simple translation of erga omnes, I would say that erga omnes is the obligations of international community as a whole. In terms of content, they may be the same with jus cogens, but erga omnes looks at the scope of obligation. Jus cogens looks at the nature of obligation. So, for example, this happened last year. There was an exchange of fire between Iran and Israel last October 2024. And what happened was that Israel launched, Israel basically killed Hassan Nasrallah, and then the Iranian leaders said that we are going to launch a retributive attack on Israel for punishing Israel for what it did. Then they launched missiles on Israel. I think it was October 2024. And what happened was that the US entered into the arena, and the US basically defense system helped Israel to detect and eject these missiles sent to it. The US justified its military action in assisting Israel by its erga omnes obligation. It said that Iran's attack was a violation of the rules of use of force, and therefore I have an obligation to defend a state that is invaded by that attack. And that was a justification based on erga omnes. Other states that helped Ukraine in its war against Russia also resorted to the same norm, saying that Russia's invasion of Ukraine is a violation of an erga omnes norm, so we have the duty to help a victim here, and that's how they justified providing arms to Ukraine. So the difference between jus cogens and erga omnes, did we understand well? I'll come back to it later. We'll work with these two concepts quite a lot. But if you want to simplify it for yourself, jus cogens basically means that not everything that you do can be governed only by consent. So this is a concept that's really derived from contract law, right? So you are free to conclude a lawful contract with anybody you deem as fit. But you cannot have a contract with somebody and agree that they are going to chop off your right arm, or basically to agree in a contract with another person to have yourself killed by them, right? So there are some public order rules that are above your agreement. Jus cogens norms are like that. Erga omnes norms are designed to authorize states to take unilateral action when they perceive a violation of international law obligations, usually reserved for the most severe cases of violation, like invasion or unlawful use of force. So basically, when a state acts against international order, or it puts at risk international security, states take it upon themselves to act unilaterally. And you see it in things like breach of nuclear non-proliferation treaty, NPT. So with sanctions against North Korea, it's the most heavily sanctioned country in the world. North Korea, Russia, and Iran are the most heavily sanctioned countries in the world. And most states have imposed sanctions against them unilaterally because of different things that they have deemed to be in violation of erga omnes norms, right? So erga omnes has a wider application than jus cogens. Jus cogens only reserved for very, very few concepts and practices. There's also, I just say this, in terms of hierarchy of norms, there is another method of norm conflict resolution in international law, and that's Article 103 of the UN Charter. And Article 103 of the UN Charter basically says that in the event of conflict between a state's obligations under other sources of international law and their obligations under the UN Charter, their obligations under the UN Charter take precedence. So basically, if there is a Security Council resolution and the Security Council resolution is against the treaty obligations of other states, then the Security Council resolution takes priority. So let's say that the UN Security Council authorizes use of force against one state, and that state has bilateral security agreements with other members of the international community, with other states in the international arena, right? So basically, let's say a state called Arcania has bilateral treaty with its neighbor called Utopia. And both states have basically have created an obligation of non-aggression towards one another. treaties of non-aggression are very, very common in international law. States basically create a mutual obligation not to invade one another, right? These are called treaties of non-aggression, very common. And the UN Security Council now issues a resolution which authorizes use of force for humanitarian purposes against Arcania. Ethiopia can do away with its obligation under the non-aggression treaty that it had with Arcania and can join the military force against Arcania.